Now back to the show. This is You and the Law with Sterling Fox on AM 650.
Welcome back to the program. David Hobbs and Ian Giroday are Hobbs Giroday in Vancouver, estate litigation professionals, lawyers both, and we're talking about will's variation. A will's variation, David Hobbs, is just a request to change the terms of a will. Is that a reasonable definition?
Yeah, that's a reasonable definition. The court's going to rewrite some or all of the distribution under the will. They're not going to change the executor, probably. They're not going to deal with creditors, but when it comes to the distribution, if the will says my son Freddie gets everything and my other two sons and daughters get nothing, then it's that distribution that is going to be subject to variation.
All right, Ian, what is this phrase? Because I've got it written down here. The duty to make adequate, just, and equitable gifts. Is this the duty of whom? The person who wrote the will in the first place, to spread it around, so to speak?
Right. That wording comes right from a section of the Wills Variation Act. So, of course, the Wills Variation Act is written law in British Columbia.
Okay.
And that's from the operative section of that act, which essentially says that a will maker, the person who makes the will, has a duty to make adequate, just, and equitable provision for their spouses in a broad sense, including common law spouses, and their children. And what is adequate, just, and equitable will depend on whether the spouse is the length of the marriage. It will depend on whether the children are minor children or adult children. There's different obligations depending on the facts.
Okay. So let's talk about, we promised we were going to before the break, so let's get right into this whole family stuff. And David, let's start with you, because I would imagine if I'm a named, or I'm a child of a person who has died, and I am not named in that person's will, but my big brother is, the law in BC says my dad had a duty to somehow or another see that I was equitably looked after like my brother, whom he named with all the loot in his will. So I'm left out in the cold. I have a pretty legitimate case for a variation or a change to that will, don't I?
Well, you may. If I add some facts to our hypothetical, then I can make it swing one way or the other.
Okay.
I think a good place to start, Sterling, in this discussion is and this is a legal concept that comes from some case law, but when we think of the duty to make the just and adequate and fair distribution, there's a legal duty and then there's a moral duty. And the law says that I owe a legal duty to my spouse, common law spouse, and my infant children, and I owe them a moral duty. So those people get legal and moral on their side.
Right.
So if I set up a contest between a spouse or an infant child and an adult child, the infant children and the spouse are going to have the upper hand, if you will, in this debate about what people should get.
Perfectly understandable under the circumstances, right?
But
right.
My adult children are owed a moral duty, no legal duty, but moral duty. So they have an upper hand over someone who is neither a spouse nor a child, who may suffer the variation if they're receiving a gift. So if my nephew is in the will or my next door neighbor is in the will, the adult child can say, well, mom or dad owed me a moral duty. They don't owe you a moral duty. And so you can prioritize people by the level of duty that the will maker owed them.
Okay.
The highest category being the legal and moral. That's my spouse and my infant children. And if you think about family law, if the simplest example is if we've been married for 30, 40 years, normal relationship, you would expect that both spouses own half of all of the family assets.
Probably, yeah.
And you would analogize to a will that you would expect at least half of that estate to go to the spouse because they own half of everything anyways. So that's sort of the starting proposition. If you take your example of children, say they're all adult children, but let's say one of the adult children is disabled. Might be a special circumstance that entitles that, or there's an expectation that that child will be treated differently under the will.
Because there would be more financial requirements for the person's quality of life that might supersede the healthier siblings.
Yeah, what is adequate and fair for that disabled person is a question which you're asking in the context of that disability. If some of the children are very wealthy and some are very poor, but then again, the reason for the poorness may be alcoholism or self-abuse, that you're the victim of your own conduct, and so the morality of treating the person poorly under the will may be moral because there was a moral reason for this, shall we say, imbalance. And so the color and the painting of the story is important to decide whether things are fair, adequate, and just. You have to get into the background of why things are the way they are.
Okay, sorry.
If I could add to that, Sterling, you actually used the phrase "under the circumstances" when you asked David that question, and that's actually wording right from the same section that I just talked about under the Act.
Okay.
It's what's adequate, just, and equitable provision in the circumstances, and David gave you a number of examples of the circumstances.
Right.
One of the other ones, of course, is you can have quite a significant imbalance in the gifting under the will, but as you look at the circumstances, you realize that the person who is on the negative side of that balance sheet actually received a property outside of the estate from the will maker, or had a significant loan that they never repaid, or any host of things that we're on the lookout for when people come in the office and have a chat with us.
Interesting. Back to the cultural example, if I can, because you just made me this description of the moral and legal duties. Mm-hmm. If I'm an old world guy who wants to leave the whole ball of wax to number one son and ignore the other children in my life, because that's the way it's always been done, the courts are going to take a look at my decision to ignore my other children in favor of number one son, but they're going to look at it through the British Columbia legal prism, aren't they, David, that says I had duties to my other children, and it doesn't matter what the old world custom was, I've ignored my duty to my other children. Or is that a reasonable extrapolation of what might be argued?
Well, it's a very interesting question you posed. Under the present law, I'm not aware of any case where there's been a discussion of what I would call an imported cultural norm from whatever culture it may come from and whatever history.
Sure.
If we just take modern day British Columbia, North America, garden variety cultural norms, then no, we're not. The court is not going to view a very unique cultural practice as being reflective of I'll call it ordinary everyday society.
Sure.
And I think the expectation today is it's this ordinary everyday society. And I suppose an example of that is if I have 3 children, absent anything else, you would expect I'd leave an equal share to each one of them.
Sure.
All other things being equal.
Mm-hmm.
And that's part of our cultural expectation. And it's a very interesting question, though, with our society changing and cultures blending and so on, whether any of this is going to, the cultural norm is always changing over time.
Yeah.
So is it going to change? I don't know, but I don't know that there's any law that reflects that yet.
What about a parent who decides to punish on their deathbed or after I'm gone, you're going to get yours. For example, I'm going to leave this child out of my will quite deliberately because this person ignored all of my requests, didn't go to college, didn't apply him or herself, didn't get, just ran with the wrong crowd, had issues with the law, was not the kind of person I would be proud to call my offspring. So we've had a very distant relationship during my lifetime, and now that my life is over, this person gets 0. And I want that very specifically indicated in my will. So that person comes to Hobbs Giroday, Ian Giroday, and says, I'm the guy. I've been cut out because my dad didn't particularly like me.
Right.
So what do I do now?
Right, so I'm the black sheep.
Yeah.
So one of the things we're going to be looking at carefully is, again, under this Wills Variation Act, there's a section of it that says the court may take into account the will maker's reasons for the provisions they made under the will and any disinheritances. And in particular, they can take into account anything that the will maker writes and signs.
Okay.
So one thing we see in our practice is that a lawyer who does take will instructions, who drafts the will, may say to that parent, "Look, Fred, you're treating your children quite differently under this will. The person who's not doing very well, they can bring a wills variation claim. So you would be well served to explain why you have done so.
Okay.
And in fact, we can even do it in writing, and I can hold it for you in your wills file, or we can attach it as a schedule to the will, or you can give it to someone, maybe your executor, to produce at the appropriate time if a wills variation claim is made."
The reason for the disinheritance.
Right. So when someone comes in on the who's on the unhappy side of that,
Right.
We're certainly exploring why the will maker made those decisions. Are they because at the end of the day, the court will take into account that evidence, or that writing, that explanation.
Sure.
But case law has established that it has to be valid and rational. So if it says he was a constant disappointment to me. All my other kids went to university, and he only went to technical school, and a court's probably not going to put a lot of stock in that. I mean, it might be true, but it's not a great reason for distinguishing between children. Or if it's even more egregious, I disapprove of his gay lifestyle or something like that. On the other, but there can be completely valid and rational reasons. I lent him money, he never paid it back. I've provided for him amply outside my estate, much to the detriment of my other children. So now it's my other children's turn.
So now a court would take a look at the reasons, the written reasons for this rather strange determination that this kid gets nothing, and the reasons may be decided by the court to be entirely appropriate.
Right. In other words, it might not be strange at all. It might be completely valid and appropriate and rational.
So, David, when someone is named in a will, what level do you have to be at in order to be unhappy enough to be able to talk to you and Ian at Hobbs Giroday? In other words, if I'm named as a beneficiary in someone's will, can I just, I'm not getting as much as I thought, can I march into your office, or do I have to be directly related to the person who died?
Well, to be a claimant under the wills variation statute, you must be a spouse, common law spouse, or a child, biological child, adopted child. We get some unusual situations, and more than I would have expected, of people who come in who are the child of the deceased, but not recognized as being the child by the family, or they...
Again, a black sheep scenario, Ian.
Or given up for adoption before the will maker established his or her life.
You may have had foster children, you may have adopted them, they may have left the home, you may not have seen them for 50 or 60 years.
Sure, yeah.
And they appear and they announce that they are the child of the deceased, and those children have a claim under the Wills Variation Act. And you get into the story of, well, why are you alienated from the deceased? Why did you not speak to each other? The deceased has a will here that says you've not talked to them for 50 years. Right. And they say, well, that's because he abused me when I was little, so I left the home. So now there's two sides to the story and two different explanations, and those the determination of whose explanation is true is very important to the wills variation issue. And whose fault is it?
Yeah, if I feel that I have been unfairly treated as a result of not being able to be included to my satisfaction in a will, and I want to go down and sit down and talk to you fellas down at Hobbs Giroday downtown, what's it going to set me back for that first chat?
Well, nothing. I mean, we don't almost invariably, we don't charge people to have a first discussion about their situation. One thing I was going to say in addition is that your question brings to mind that if it's a small estate, $50,000 estate or $100,000 estate, there may be many beneficiaries. Right. Then the economics of fighting about that estate may not be it may not be economical.
More trouble than it's worth.
And the other thing is there's a legal principle that flows from the cases, which is larger estates have more to go around. i.e. you can make everybody happy with a larger estate. You can give something to everyone.
Right.
But if you have a small estate, then you don't have that economic ability to be generous, shall we say, with everyone. And so there's a different analysis for large estates than small estates.
David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver on this episode of You and the Law here on AM 650. And we'll be right back.
This is You and the Law. There's more of the show still ahead on AM 650.